Thank you for joining this dialogue on the role of the Caribbean in the development of international law, which is being hosted by the Caribbean branch of the International Law Association in collaboration with the Faculty of Law of the University of the West Indies, Cave Hill. One of the objects of the ILA Caribbean branch, which was established in 2014, is to promote the understanding and the progressive development of international law in the Caribbean. We are pleased that today's dialogue has the endorsement and support of the law faculty of the University of the West Indies, as the university also assigns value to the development of international law in the region and to regional approaches to international law. My name is Chantal Ononaiwu. I'm the president of the ILA Caribbean branch. I'm so pleased on behalf of the ILA Caribbean branch to welcome you all. And I will now invite Dr. Mohsen Alatar, the Dean of the Faculty of Law at the University of the West Indies, Cave Hill, to provide some remarks. Dr. Alatar, please.
Many thanks for that introduction. I'm very excited to be speaking to you today briefly about this, in large part because I'm excited for what's to come. And I say that I'm excited for what's to come because most law faculties do not actually teach international law. What they teach is European international law, European subjectivity posing as a type of human objectivity. And that is the nature then of Eurocentrism. Mainstream international law, as we understand it, was devised by Europe. But it was devised by Europe during the colonial period, and it was devised with the aim of legitimizing the conquest, the plunder, and the colonization of lands and peoples beyond Europe. Now, this is now well known. It is well known in large part because of a scholarly, some might even say intellectual movement known as TWAIL, Third World Approaches to International Law. But it is also well known because of anti-colonial, post-colonial, and decolonial scholars. Now, TWAIL and much of the critical scholarship that relates to international law has built itself around a counter-narrative mode of research and engagement. And what this counter-narrative seeks to do is to tell the story of international law, of European international law, through the lives and the deaths of those who suffered it. Now, TWAIL and much of this critical body of scholarship is at the point where everyone is asking, all right, what next? We understand the history, we understand the depravity, we understand the Eurocentricity, but what next? Can European international law be indigenized? Can it be regionalized? Could it even be universalized? Now, many are doubtful. They are doubtful because, for one, Europe is not going anywhere. And Europe has very little interest in surrendering many of the privileges that the regime they structured provides. And for two, many beyond European borders have actually internalized European ways of thinking, European ways of being. And this necessarily applies to legal relations as well. But there are many others who are hopeful, in part because Europe is not the force it once was, but more importantly, because regional integration, as it is taking place across the Caribbean, across South America, across Asia, across Africa, these are now at levels unseen in human history. And all of these different forms of regional integration necessitate international law, and lots of it. So the opportunity and impetus for regions to develop their own approaches towards international law has never been stronger. And as you will learn today, the Caribbean is one of those regions. Now, its history is marked by some of the worst depravities that Europe ever committed. The earliest forms of European genocide took place right here on these very islands. Entire populations decimated, wiped out. And even today, there remain many colonies. There's no apology, there are no reparations, there is no developmental compact, and I haven't even spoken about slavery yet. So of course, what next indeed for the Caribbean? And that is what we are here to find out today. How is a small group or a group of small island states, denoted by various legal transplants, common law, French, Spanish, and Dutch versions of civil law, how are they, these islands, helping to shape international legal relations? Are we following a model of Cuban socialism, of Guyanese capitalism, of Barbadian social welfarism? Does Calypso play a part? I suspect the mighty Gabby would say it does. And what of CARICOM? What of the Organization of Eastern Caribbean States? What contribution are they making to this Caribbean approach to international law? And so, mainstream international law may be Eurocentric, but the rest of the world is not. Each region is crafting new approaches towards international legal relations. And today, we will learn just how meaningful Caribbean approaches to international law are. Thank you very much, and I look forward to this panel.
Thank you, Dr. Al-Attar, for those very stimulating opening remarks. You've set, I think, a very good tone for our dialogue today. And today's dialogue will be exploring the role of the Caribbean in the development of the international law. We will be examining ways in which the Caribbean has been at the forefront of the development of international law, and we will consider the region's influence on the development of various fields of international law. Now, what's key as well is that we will also be discussing the importance of the region remaining an active participant in the development of international law. We are so honored to have this dialogue led by a very distinguished panel of speakers. The Honorable Mr. Justice Winston Anderson, Ambassador Janine Felson, and Professor Stephen Vasciannie. Now, I have a very difficult task in front of me, which is to briefly introduce each panelist given their vast accomplishments, but I will do so now. Now, Justice Winston Anderson has been a judge of the Caribbean Court of Justice since 2010. Prior to his elevation to the bench, he was a professor of international law at the University of the West Indies, and he served as the General Counsel of CARICOM and the Executive Director of the Caribbean Law Institute Center. A recognized expert in environmental law, Justice Anderson has served on the International Advisory Council of the United Nations Environment Program, the Advisory Commission on Environmental Law to the Organization of American States, and on the Economic Commission for Latin America and the Caribbean Expert Group on Principle 10 of the Rio Declaration on Environment and Development. Janine Felson is an ambassador of Belize and strategic advisor to the Alliance of Small Island States. She has been a leading voice for small island developing states in key negotiations, including the 2030 Agenda for Sustainable Development, the Paris Agreement, and the Intergovernmental Conference for a New High Seas Treaty on Marine Biological Diversity. Ambassador Felson is concurrently completing a fellowship with the Melbourne Sustainable Society Institute, where she's focused on integrated approaches to global policymaking on climate, oceans, and sustainable development. Stephen Vasciannie is a professor of international law at the University of the West Indies, Mona. He has served as Jamaica's ambassador to the USA and the Organization of American States, president of the University of Technology, Jamaica, and principal of the Norman Manley Law School. He has been a member of the United Nations International Law Commission and the Inter-American Juridical Committee of the OAS. He also has been a Deputy Solicitor General responsible for international affairs in the Attorney General's Chambers, Jamaica. And his most recent book, published this year, is entitled Caribbean Essays on Law and Policy. Now, in addition to our speakers, we would love to hear from you, our participants. And so we invite you to use the Q&A feature at the bottom of your screen to pose questions to our panelists, or to make observations or comments about the issues being discussed. This will allow us to direct your questions to the panelists during the first part of the dialogue and the dedicated Q&A session to follow. So let's get straight into our panel discussion. Now, as you may know, Justice Adrian Saunders, who's the president of the CCJ, he has commented that international law is of profound value to the people of the Caribbean, and that the Caribbean has always played an outsized role in the field of international law. So let's start our dialogue by examining the participation of the Caribbean in the development of international law, including through participation in treaty making and the work of international tribunals and international bodies. So I'm going to ask at this stage each of our three panelists a series of questions and kindly ask them to respond within 10 minutes. And I'm going to start with Justice Anderson. Justice Anderson, in 2019, the CCJ Academy for Law, which you chair, honored eminent Caribbean international law jurists. And in so doing, the Academy recognized their contribution to the development of international law and respect for international law in the Caribbean. Justice Anderson, could you please highlight what, in your view, are the major contributions which Caribbean jurists have made to international law? Justice Anderson, please.
Good morning, everybody. Thank you, Madam Moderator. First, let me say that it is a distinct privilege to contribute to a discussion of the role of the Caribbean in the development of international law. And it is a great honor to do so in the company of my fellow panelists, two very distinguished international lawyers, Ambassador Felson, and my friend of over 30 years, Professor Vasciannie. The moderator was kind enough to refer to a project conducted by the CCJ Academy last year, which ended with a celebratory awards event and a publication of the works of several eminent Caribbean international jurists. As my entry point into this morning's topic, I would like to say briefly something about why and how the project was undertaken, and about some of the things we discovered during the lifetime of working on it. Now, as to why the project was undertaken, there were two main reasons. First, it seems obvious that the Caribbean makes a disproportionate contribution to international law. After all, the region is mainly a group of small island states, many with populations of under 300,000 people, in some cases 100,000 people. Compare that to the 340 million people of the US and the over 1.2 billion each in China and India. And yet the reality is that the Caribbean has had a visible and significant presence in many international fora and institutions. We punch above our weight, so to speak. And the Academy Project aimed to chronicle and document some of our Caribbean achievements. Secondly, as foreshadowed in the biblical reference to a prophet not having honor in his own country, there's a general lack of appreciation within the region for the contribution of Caribbean jurists to international law. The subject is often considered abstract or esoteric, and law students typically do not rush to engage and enroll in a course in international law. They read the subject in mass only where there is a compulsion that they should do so. In this way, there's a great ignorance of the inheritance to which our young attorneys are heir. And so the Academy wanted to draw out into the open and to celebrate the very rich contributions made by the Caribbean to international law. A word about the project process and content. In 2018, a committee was established by the Academy to seek to identify, by various means, direct and indirect, eminent Caribbean international law jurists. In fact, 19 were identified, 6 of whom, unfortunately, had by then died. These 19 jurists were academics, diplomats, international litigators, and judges. They had worked or were working in the Ministries of Foreign Affairs, United Nations, the National Court of Justice, International Law Commission, the WTO, International Criminal Tribunals, the Law to Sea Tribunal, International Seabed Authority, UNEP, and CARICOM. Selections of the written works of these jurists were published in a 200-page book in October 2019. Now, the project revealed or emphasized certain significant aspects. First, the Caribbean has a strong pedigree in international law. Modern international law is generally taken to have had its origins in Europe in the 15th, 16th, and 17th centuries, corresponding with the so-called European discovery of the West Indies. The Treaty of Tordesillas of 1494 was supposed to settle ownership of the New World between Spain and Portugal. Over 525 years later, it is still going strong. It was relied upon by Guatemala in its 2019 border dispute with Belize before the ICJ. The Caribbean has also had a direct influence in the development of the laws of war and peace by Hugo Grotius, especially in the context of the law of the sea. We also contributed significantly to the doctrine of self-determination from the various treaties between the Maroons and the British in the first half of the 18th century to the American and Haitian revolutions in the latter part of the same 18th century. Secondly, the project reinforced the emergence of the Caribbean as a creature of international law. The quintessential manifestation of this is, of course, the Caribbean Community, or CARICOM, which is an international legal person having legal rights and obligations on the international plane. Caribbean nation states are themselves also creations of international law and owe much to the law of the sea, whether because they are islands, as in most cases, or because they are mainland states, which, like island states, have jurisdictional access to excessive areas of the sea. Small wonder then that many of our international lawyers have worked in the law of the sea. At the same time, the economic vulnerability and the military weakness of the Caribbean makes the region heavily dependent on the peaceful application of the rule of international law. Thirdly, it is heartening to be reminded that the sterling work of our Caribbean jurists has been widely recognized and appreciated by the international community. Many of our nationals have risen to positions of ultimate leadership in the international legal order. Sir Dennis Barron of St. Kitts and Nevis, formerly president of the CCJ, has served as president of the International Criminal Tribunal for Rwanda. Judge Patrick Robinson of Jamaica, currently judge on the ICJ, has served as president of the International Criminal Tribunal for the former Yugoslavia. Judge Dolliver Nelson of Grenada served as president of the International Tribunal for the Law of the Sea. And Sir Shridath Ramphal, Guyanese national, and a founding father of Caribbean integration, was a long-standing Secretary General of the Commonwealth of Nations. Initiatives such as the Caribbean, the CCJ Academy project, and as this started by the Caribbean branch of the ILA, are attempts to remind the region of the work of the founding legal architects who have placed the Caribbean on the map of international law. These initiatives also invite another generation of Caribbean lawyers to walk among the edifices erected by their forebears and to be inspired to carry forward the work of the Caribbean contribution to the further development of international law. And if at the end of this morning, some young lawyer is inspired to do this, I think we would have been successful. Thank you, Madam Moderator.
Thank you so much, Justice Anderson, for such a timely reminder of the various ways in which the region has contributed to the development of international law. I mean, I'm amazed at how much you were able to span in your intervention. And I would just urge attendees, if they haven't yet done so, to probably delve deeper by reading the publication to which Justice Anderson referred. But certainly one of the points that you made that I know we will pick up on later in the discussion is the perception of international law amongst students of law in the region. It is definitely something we're going to pick up on later in the conversation because it's so critical to the question of how we're going to remain an active participant in international law. So Justice Anderson, thank you so much again for your intervention. Now, you did point to already in your presentation, in your response, several fields of law in which the region has contributed. And we're going to pick up on that theme when I now move to Ambassador Felson. Ambassador Felson, you have wide-ranging experience as a senior diplomat. You've advocated for the interests of your country, Belize, the Caribbean community, and small states. And so Ambassador Felson, drawing on that experience, including your service as Belize's Deputy Permanent Representative to the United Nations, could you please highlight important ways in which the Caribbean has influenced development of international commitments in fields such as climate change, sustainable development, and marine biodiversity? Ambassador Felson, please.
Thank you very much, Dr. Ononaiwu, and thank you very much to the International Law Association and the University of West Indies for hosting this panel. It is a pleasure to be on the panel with such esteemed and persons who I think I've advocated for, certainly Professor Vasciannie in relation to the ILC. So it's a pleasure to be on a panel with you. Not in person, but in Zoom. So just to pick up from where Justice Anderson left off, and to underscore, of course, the Caribbean has had an important role in the development of international law in different concepts and in different contexts. And it still continues to have a very important role in that regard. Certainly more recently in relation to climate change and sustainable development, and as you mentioned, the oceans related treaty making processes. But I actually wanted to focus on how do we actually have influence? What exactly it is that gives us that ability to influence international law? And there are 5 areas that I think are worth reflecting on. The first being that it's been very important for our approach that the Caribbean has been so coordinated in the treaty making processes as well as in global policy development processes. We've done that because we are stronger in numbers, of course. So we've done that through the Caribbean community, but we've also leveraged that in relation to other groupings. So in relation to the Alliance of Small Island States, which is made up of 44 states, and as well in relation to the group of 77 in China. So by coordinating, coming to common positions on specific areas for advocacy, we've then been able to leverage that in the context of different groupings in order to advance our interests on various global policy and legal related issues. So the second point is that point, is the leverage in the numbers. I think it's important to note that, yes, we're 14 CARICOM member states. In the context of 44 member states, that's still significant. A quarter, the Alliance of Small Island States represent a quarter of the UN membership. That's important because we then have to use the multilateral process to advance our interests. The group of 77 in China represents 2/3 of the UN membership. So if we can have influence within that group, we then have even greater influence in terms of negotiations. And I think there was a point that was raised earlier about the importance of the rule of law. And I would add to that the importance of multilateralism to ensure that we are able to have that influence. A third element that I think is relevant for our audience to recognize is that we've sort of benchmarked ambition through a SIDS narrative. So in context of climate change, we've often been tagged as a canary in the coal mine. And that may seem diminutive, but it's actually a point of leverage. And that's important because it creates a tangible construct of a global problem and then orients a solution towards a higher ambition that addresses our particular needs. The fourth area that has been very important in how we influence the negotiations for treaty and law in general is the emphasis that we've placed on science. Science as part of diplomacy. That has been very important in the context of the climate change, in determining certain benchmarks for instance, for the Paris Agreement. And it's also going to be very critical in the context of the High Seas Treaty for marine biodiversity. And the last thing, we punch above our weight. We also are the ones who set the bar of ambition. We don't go for the lowest common denominator. We go for the highest. And in that regard, we've been able to really push agendas forward, especially in climate change. And I think this has come out very clearly in the Paris Agreement, where the efforts of the Caribbean, under the chairmanship of Grenada as the chair of the Alliance of Small Island States, and then through successive chairs, it's through that advocacy of these various groupings, but headed by the Caribbean, that we were able to push for the 1.5 degree long-term temperature goal. And I think that's a very significant accomplishment for the Caribbean, for small island developing states in general, because it really is the focus now of where climate action and ambition needs to be. So we've not only set the bar, we've actually now changed or oriented a whole thinking on international cooperation towards, the types of actions that will be needed to be taken by states to achieve a transformation of society and economies. And I just wanted to go through those 5 points in relation to the 1.5 to Stay Alive campaign that the Caribbean launched, and then that was taken over more internationally. So there was a coordinated approach. I mentioned the importance of science. Grenada commissioned a report on the different scenarios of impacts for climate change scenarios that would impact the Caribbean and other small island developing states. And they used that to consolidate support behind 1.5 degrees. This was all the way back in 2008. We're the ones who put it on the table, and we're the ones who championed it moving forward. In 2009, when we met at the Copenhagen conference, we couldn't get the 1.5 degree goal accepted, but Copenhagen conference had its own difficulties, management of process. But in any case, what was significant is that we were able to ensure that there would be a periodic review of the long-term temperature goal which would then include an opportunity to look into the 1.5 degree. I think that's significant because we did not back down. We were persistent, and we used our diplomacy to push forward that agenda. The third aspect of that is that it then shows how we use the multilateral process to our advantage. Outside of the process, we might have less leverage. Within the process, because of our numbers, we have more leverage for negotiating. So we created a process for periodic review of a long-term temperature goal, the result of which reinforced our position on 1.5. That was a report called the Structured Expert Dialogue Report, which we then took from Peru into Paris. And that was very significant, an important platform for our members, our Caribbean members, to push for this objective within the Paris Agreement, something that is significant because of the existential threat that climate change poses to small island developing states in the Caribbean, but across the globe. So we use that coordinated approach. We leveraged our numbers. We used the science to back our interests, and we ensured that we benchmark ambition based on our own context. And in that way, we've had tremendous impact on the shaping of the climate change agreement. But I would say it's also something that's been replicated in the context of the High Seas Treaty negotiation on marine biodiversity. In this case, we're working more within the context of the Caribbean community. We're using our different levels of support. We're using technical negotiators. We're drawing on region-wide experts, and we're also using the Caribbean Community Secretariat to help us consolidate support, taking that all the way up to the ministerial level. And I think that complete ecosystem for our negotiating stance is very important to ensure that we can maintain the momentum, maintain our positions, going through the negotiations, and so that we can, in the end, hopefully influence the shaping of the High Seas Treaty that would be beneficial to the Caribbean. So I just wanted to give you that sort of more practical insight into how we've been able to influence the negotiations. Those five key areas have been significant in the Caribbean, really pushing forward, really putting its weight into the development of international law. Thank you very much.
Thank you so much, Ambassador Felson. And what was so interesting about your intervention was how it connected to several strands of Justice Anderson's observations. Justice Anderson had observed initially that, you know, CARICOM is a creature of international law. And you've demonstrated how that creature of international law has been used strategically to enable the region to essentially be a thought leader and an influencer of rules, to not necessarily be a taker of rules, but also to be a shaper and influencer of rules. And importantly, to do so being very guided by our context in the region. So in other words, you know, we're influencing in a way which is true to the service of our own interests. And so I was very struck by how you so clearly illustrated the ways in which we are, in a very contemporary way, actually continuing to be shapers and influencers of international law. So thank you so much for that intervention. And so in turning now to Professor Vasciannie, I'm hoping that we can also unpack how the region has influenced international law in another important way, and that is in participation in international bodies that actually do influence the development of international law. So Professor Vasciannie, by my count, you are one of 4 Caribbean nationals who have served on the International Law Commission. And this is an international body which helps to promote the progressive development and codification of international law. What have been some of the most important contributions, in your view, of the Caribbean to the development of international law through the participation of its experts in the work of bodies like the International Law Commission? That's the first part of my question. And then secondly, drawing on your experience as Jamaica's Deputy Solicitor General with responsibility for international affairs, could you also highlight other contributions of the Caribbean to the development of international law, including with respect to the inter-American system? So Professor Vasciannie, please.
Thank you, Dr. Ononaiwu. Thank you very much for this invitation and for your kind introduction. I would like to say good morning to everyone and mention that it's not every day that I get to be on a panel with a distinguished judge, an excellent ambassador, a dean of standing, and you, Dr. Ononaiwu. So thank you very much for this opportunity. And I should also thank Ambassador Felson for the support which was given to me in the context of the International Law Commission, and mention to Judge Anderson that by my calculation, it's closer to 40 years than to 30 years that we have been friends. To the topic, I'd like to say, first of all, that international law is a dialectical process. So Caribbean countries will have a perspective, thesis. European countries will say, no, we disagree with that. Antithesis. Then there's a discussion, and you get to a synthesis. And I mention that because that is exactly how the International Law Commission works. There is a thesis which is put forward by the special rapporteur on a given subject. It might be expulsion of aliens, it might be treatment of persons in disaster environments, and so on. And then each member of the commission gives her or his view in response to that thesis, so that you have a series of anti-theses being presented. And then out of that, almost in a parliamentary way, you get a resulting document which constitutes draft articles which are presented to the UN General Assembly for consideration. So you're going to get in these discussions all views from different parts of the world. And that's also true of the inter-American system as well, where a particular state has an issue, it presents its position on that issue, and the states respond to the position and seek a final solution. In the context of the OAS, I can mention that sometimes these discussions go into the morning, 2 a.m. and so on, just trying to get to the synthesis. All right, that's one point, dialectical process. In that dialectical process, Caribbean countries have been very active at all levels and in different organizations. The second point I'd like to make, general point, is that for this topic, we are understandably talking about the contribution of the Caribbean in international law. And that presupposes that there is one thing called international law, that there's an international law rule on X or on Y. But in the real world, that's not how it works. In the real world, you're going to find that, well, there may be a regional rule of international law, as recognized by the ICJ in the asylum case and so on. There may be a regional rule. So there may be a CARICOM rule on the treatment of aliens. And then there might even be a rule applicable as between 2 states, arising from a special custom or arising from a bilateral treaty arrangement. And then there will be some countries that are party to a multilateral treaty and some that are not. So you have to look at treaty law and you have to look at customary international law. So on any one point, there are a whole series of rules of international law vying to be binding on a given state. So Caribbean countries have had to operate in that context. And I guess one of the important points to note is that this requires quite a few lawyers. You need lawyers who are experts in different areas. And sometimes I think Caribbean countries could invest more in having lawyers for international law because there are so many diverse elements to a given rule. My third general point is that the role of the Caribbean has been, to a large extent, defined by how we perceive ourselves. We perceive ourselves as small, economically vulnerable countries which respect the rule of law. And each of those elements is important. We are small. Because we are small or perceive ourselves in that way, we are insistent that might is not necessarily right. So you might have military strength, but that doesn't mean that we will accept rules that you are advancing. Might is not necessarily right. And you must follow international law rules about the use of force. Secondly, because we are small, we have constantly had to insist on the sovereign equality of states. There will be a temptation among larger, powerful states to say, well, if your population is 60,000, maybe you shouldn't be treated in the same way as a country with a population of X million. So Caribbean countries have had to insist on the sovereign equality of states. And this is not a theoretical proposition. There is a former president of the International Court of Justice who has actually written that Caribbean microstates should be treated differently from other larger states. So Caribbean microstates have had to insist on their position through the sovereign equality of states. And also, we have had to insist on sovereignty, which is different from sovereign equality. Sovereign equality implies that we are treated equally, especially in the context of international organizations. But sovereignty connotes the idea that what takes place in our countries are subject to the rules of our countries, so that international matters are addressed internationally, but domestic matters are addressed domestically. And that's affirmed by Article 2, Paragraph 7 of the UN Charter. All right, so we're small. We are economically vulnerable. And that has resulted in a position in international law for the Caribbean. We always seek to achieve change in international law, which will promote the interests of developing countries. So we align ourselves in the OAS with CELAC, in the UN with a group of 77, and we always seek to advance the perspective of developing countries. There may be different perspectives, but that is our touchstone. What is the position of developing countries on this international law issue? And we respect the rule of law. That component pertains to matters such as human rights, because we pride ourselves or present ourselves as being in the mainstream of human rights promotion and protection. Even though we may have challenges that are not fully understood by European countries or by other developed countries, we present ourselves as being committed to the rule of law. And this is topical because last week Jamaica made its Universal Periodic Review presentation to the UN Human Rights Council. And that was our starting point. We're committed to the rule of law. We have some challenges, but we're committed. And so it provided us with an opportunity to explain our perspectives. But we are committed to the rule of law. All right. There are a number of particular areas where Caribbean countries have marked out a distinct role, and I mentioned some. With respect to the sources of international law, Caribbean countries have maintained that each country should have weight in the development of customary rules. And Caribbean countries have expressed, or at least Jamaica has expressed, some skepticism about those rules of customary law that apply differently for post-colonial states. For example, when post-colonial states became independent, we had a body of law imposed on us, a body of law developed in the European context and in the North American context. But we had to accept those as representing the law. Occasionally, there are questions about that. And the way Caribbean countries have sought to get around that reality is by seeking to encourage the negotiation of treaties that depart from the law that existed under the colonial period. And one example of that I think is quite graphic is the Law of the Sea Convention. Caribbean countries were very, very active in the negotiation of the Law of the Sea Convention. So much so that the headquarters of the Seabed Authority finds itself in Kingston. That is a statement of influence. Now, Caribbean countries pushed for changes in the law of the sea, the customary law of the sea, that would reflect the economic development interests of developing countries. So that's how we have sought to get around it. Secondly, use of force. Caribbean countries have been firm on the idea that there is to be no use of force in international relations, subject to exceptions, self-defense, and Chapter 7 of the UN Charter. But on occasion, we have been involved in the use of force, intervening in Grenada and supporting intervention in Haiti. Grenada 1983, Haiti in 1994. So in keeping with our position on the rule of law, we have had to explain why in those instances we were not so firm on the rule that says no use of force. And I think there are explanations that can work in the context of the Haiti example. In the context of Grenada, I think there was a dilemma. I think the rule was clear, you shouldn't intervene. But on the other hand, there was a political reality on the ground in Grenada, which Caribbean people felt required intervention. So there is the legal position versus the moral challenge that was presented. To this day, people argue about it. But I just mentioned it as a possible departure from our commitment to the rules about use of force. Investment. Our objective is economic development. We have entered, well, before this, we sought to shape the development of investment law through a code of conduct on multinational corporations. But that became unstuck by resistance from developed countries that didn't accept the propositions we were putting forward, didn't accept our theses. And so we have a situation where Caribbean countries seeking to promote development have now entered into a whole series of bilateral investment treaties, which set out treaty law relating to investment. There's a debate about what the customary law is, but we support bilateral investment treaties on various issues. All right, I mentioned the law of the sea already, so in the interest of time, I'll jump on. But to say that in the context of the law of the sea, we have influenced the rules concerning archipelagic states. We have sought to influence rules on nuclear shipment. We have influenced rules on the development of geographically disadvantaged states. And we have influenced rules relating to the shipwright arrangements. Also, in the context of dispute settlement, we have had the Barbados, Trinidad and Tobago maritime case, the flying fish case, which has presented certain rules coming out of our Caribbean situation. All right, self-determination is another area where Caribbean countries have been very active in the International Law Commission, in the UN, and in various other fora. We fully support Resolution 1514 on the Declaration of the Granting of Independence to Colonial Peoples and Territories. But we also support, in this context, the development of the law on self-determination. So the Chagos Islands case has seen an important separate opinion by Judge Robinson, in which he has pointed out that self-determination is not only Resolution 1514, but other resolutions as well. In the context of self-determination, we have also supported self-determination with respect to title to territory. Justice Anderson mentioned the issue of the Guatemala-Belize conflict. The position of the Caribbean is that Belize must remain in its current integral form without any territory being taken off on the basis of self-determination. This is what the people of Belize want, and Caribbean countries have been firm on that. The other position is that, well, you must go back to the Spanish period and apply a concept known as uti possidetis, and that might suggest that Guatemala gets a piece of Belize. But the Caribbean countries have said, no, self-determination is the key factor. Self-determination has also played a role in our contribution to the anti-apartheid struggle up to the 90s, and to sanctions against South Africa, actions against Rhodesia, and support for liberation movements, because these were liberation movements seeking self-determination. And the Caribbean was there in the forefront at the UN. And in the context of Jamaica, you know, there were some people who were saying, why should Jamaica contribute money to the liberation struggles in Angola, Mozambique? The rule of law, but also because it supports self-determination. So we spent the money well. All right, human rights, as I say, we try to be in the mainstream. There are sometimes challenges and there's some resources. And finally, the Caribbean Court of Justice and CARICOM. The Caribbean Court of Justice presents a new avenue for the development of international law through academics read. Sometimes some of us agree with the decision, sometimes we find challenging propositions, but it's there, and that is where I would.
Thank you so much, Professor Vasciannie, for that, interesting and wide-ranging intervention. I mean, you reminded us again of the various fields of international law in which the Caribbean has made a contribution. And what I found so interesting about your intervention, which complemented Ambassador Felson's, is you spoke to how our perception of ourselves influences in so many ways the positions that we put forward in so many spheres. And I mean, in my specific area of international trade law, I was checking so many boxes, as you were mentioning, our perception of ourselves as small, economically vulnerable, and being committed to the rule of law, because in that sphere, that's exactly how we often represent, that's the lens through which we often represent our position. So thank you so much. I just wanted to move to the next phase of our dialogue, where here we want to speak a little bit more about the future, specifically the continuation of the region's contribution to the development of international law. Now, to some extent, we've had contemporary accounts of how we're already, doing this, but how do we sustain the kind of influence that we have had on the development of international law? So here I'm going to ask each panelist the same question, but perhaps invite each panelist to answer the question from a slightly different perspective. And the question here is, really, in your view, what will be critical to the Caribbean remaining an active participant in the further development of international law? So Justice Anderson, if you could perhaps kick off by please responding from the perspective of the work of international tribunals. Thank you.
Well, I think the starting point requires us going back, unfortunately, and back to what I said at the beginning, that we ought to recognize, and I say we, I mean all Caribbean people, judges, academics, diplomats, but especially the young lawyers, especially people who are now at the law faculty or the law schools, that we really are inheritors of a rich legacy. You really have to start there, because unless you know the place that our forebears have carved for us in the international space, then you're not going to have the inspiration to aspire. So that's the very, very first thing I would say. And I mentioned some of the institutions, international tribunals earlier. The International Court of Justice, the premier international tribunal. We have had people sit on that tribunal. We have had at least two. Stephen would remind me if I'm going wrong here, but we had Justice Shahabuddin out of Guyana. So I think our first person from the Caribbean, English-speaking Caribbean, to sit. And of course, now we have our own Patrick Robinson. We have had lots of people sit on the United Nations Law of the Sea Tribunal for the Law of the Sea. I have sort of lost count, but I think at least 8 of our nationals have sat on that tribunal. We have the Inter-American Court, we have the Inter-American Commission on Human Rights. We have had that populated by Caribbean people as well. And of course, the International Criminal Court. Not only have we sat on that, but, and I think as the ambassador may have hinted earlier, we were responsible largely for the creation of that International Criminal Court. So that's the very first thing. The second thing, as I said, we have to claim the heritage. You know, we have to own it. And if we don't, then other people will. So if you look at many of these institutions, they have a dwindling degree of participation by Caribbean peoples since they were established. We have retreated, unfortunately, from our leadership role in these tribunals. And I give you just one practical example, being the tribunal on the law of the sea. So that when it was originally established, again, going back to what Stephen said earlier in terms of the contribution of Caribbean people towards it, we had I think there were 3 judges from the Caribbean who were on that tribunal. And then, of course, we got sort of pushed out of that, again, because I don't think we were aggressive enough to maintain our standing there. We got pushed down to 2. And then there was 1. And I so happened to have met that one in an airport in the Caribbean. He was in his 80s. And he was saying to me, well, look, you know, I'm tired. I cannot go any longer. And when I leave, there's not going to be any Caribbean person on the tribunal. So, of course, I was moved to engage in some initiatives. And I am very, very pleased to know now that, I'll say humbly and modestly, part as a result of those initiatives. We now have Dr. Cathy Brown, who is replacing Justice Lucky on the tribunal. But without that kind of active assertion of our right in relation to these tribunals, we are going to go missing. Now, we need to, of course, make sure that our candidates who go up are well qualified. So the first thing is that you have to be trained in international law. You have to not only read the course, because you are compelled to do so, but demonstrate an active interest in international law. You have to go beyond the graduate, the undergraduate course, LLB, and do some graduate work and do some postgraduate work. You know, you have also to get some experience in the field, perhaps working in the Ministry of Foreign Affairs or in some other international institution. And then finally, one has to get the support of one's colleagues. You need to know what is happening, know when there's a vacancy, and there should be, you know, means by which we Caribbean people can communicate with each other as to when vacancies arise. We have lots of means of communication. So we ought to know when there are vacancies that arise. And then we're going to need the support of our Caribbean nations. As was mentioned, we have a lot of votes in terms of numbers. So we need to secure all of those numbers. I tell you this, that unless we know what's going on though, we're likely to split those votes, because at the time when Dr. Brown was going forward to the tribunal, there were two other people traversing the Caribbean vying for the same position and seeking support from our various governments for that position. Now, you know, so we need to coordinate, we need to synchronize our activities. We need to reach out, get the support, first of all, of the region, and then, of course, of friends of the region. And, you know, make sure that our good, competent, experienced persons are put forward to serve in these tribunals.
Thank you so much, Justice Anderson. So much clarity provided in your response with respect to the kind of work which is really required for us to continue to play an important role in the development of international law through participation in international tribunals. The theme of coordination, again, coming through here. And again, the theme of continuing interest on the part of the next generation of lawyers in this field, and how that interest really needs to be sustained. So thank you so much for your intervention. Ambassador Felson, in your response with respect to this question of what's going to be critical to the Caribbean remaining an active participant in the development of international law, could you concentrate on the negotiation of international commitments? Thank you.
Sure, no problem. I fully endorse what Justice Anderson just said, though. Absolutely critical that we claim our heritage and pursue it in many different areas. So the development of international law isn't just about jurists. It does involve policymakers. It's very important that our political leaders are au fait with the issues that are current. It is also a matter for different stakeholders who will be impacted by the rules we set at the international level. So I think I would like to emphasize that in relation to the negotiations, it's very important to have a strong link between the technical and political levels. And equally important is the engagement of stakeholders to ensure that you have an effective and ongoing engagement with them so that they are in fact reinforcing positions that you are, or helping you reinforce your positions or refine your positions so that you can adequately represent the interests of the region. And I also want to emphasize the importance of regional institutions such as the Caribbean Community to serve as that, that glue for these different types of relationships and to facilitate a steady and ongoing engagement between the different levels, technical, political, but as well as stakeholder. We had an excellent engagement with one of the regional institutes, the Caribbean Natural Resources Institute, who the CARICOM engaged to conduct a stakeholder engagement on the BBNJ Treaty, because someone hears about High Seas Treaty and marine biodiversity. Why is that relevant to us? It's very relevant to us. It's very relevant to our day-to-day reliance on ocean resources. So we had an engagement, and it's really impressive. If you go onto CANARI's website, you will see a full GIS mapping of issues that are of interest to the Caribbean. And that's going to be important for us in concluding this next treaty. So that type of engagement needs to be concretized in practical ways. And we have social media now, so it's easier to reach out and to gather inputs and to remain engaged. I also want to just underscore some things that Justice Anderson mentioned. And this relates a lot to capacity building of institutions and individuals. So yes, we do need to invest in teaching international law. We do need to invest in research and development, so bringing a Caribbean perspective to international legal matters. You know, picking up from where the, Dean Alatar mentioned earlier, it's not about European law. It's really our perspectives on what obtains now in the international realm. And promoting international engagement, undertaking targeted approaches to promote Caribbean jurists in international bodies, and creating platforms just like this one to expose our new generation and the next generation of practitioners in the field of law. Our engagement for sure is not by accident. It has to be by design, and we must keep it that way. Thanks.
Thank you so much, Ambassador Felson. And again, what's so heartening about the conversation, the dialogue that we're having, is people are sharing so much from their personal experiences and providing very tangible, practical actions that the region really needs to prioritize in order to remain an important player in this space. Thank you so much. Now, last but not least, Professor Vasciannie, I wanted to know if you could respond to the same question. What would be critical, what will be critical to the region remaining an active participant in the further development of international law? If you could respond to that question while concentrating on the study of international law. Professor Vasciannie, please.
Okay, thank you, Dr. Ononaiwu. First of all, I didn't hear all of what was being said by Ambassador Felson or Justice Anderson. So I may repeat some of what they said. I apologize for that. What I would say is that we need, in order to keep interest in international law, we need a system of getting more information relating to the Caribbean practice, Caribbean state practice. If you want to study international law and write about international law, it is sometimes a bit challenging to get information that is relevant. For example, I have noted Dr. Ononaiwu's presentation in relation to arbitration experience in the Caribbean, commercial arbitration cases. But if you want to find out about the most recent arbitration matter concerning a given Caribbean state, you might not. It might be a secret decision or just not available. So we need greater access to information about Caribbean state practice. Secondly, we need, in the training of lawyers, perhaps to put an international law course at the law school level. Right now, in the region, you do international law at the faculty level, but there is no law school level course. And that should be corrected, because given the growing importance of international law, as was mentioned in response to Judge Sancroft, it's of greater relevance, as mentioned by Justice Anderson. That presents the case for having more teaching of international law at the level of the practitioner or the person about to become a practitioner. Then some Caribbean countries need to be more willing to ratify certain treaties or to correct situations in relation to the ratification of treaties, because that will help to keep international law alive on particular topics. I have in mind especially Jamaica's withdrawal from the first optional protocol to the ICCPR. There was a reason at the time for that withdrawal, and I accept that. But that reason is now gone. And so it is possible for Jamaica to re-enter the first optional protocol to the ICCPR. Similarly, it is possible for for Jamaica to become a party to the International Criminal Court arrangements, to the Rome Statute. And last week, the Minister of Foreign Affairs of Jamaica said that Jamaica was taking the steps to become a party. But there were issues relating to drafting the relevant legislation and so on. So that might be corrected soon. But I think we need to enter that arrangement because it generates interest in international law among students. I think Justice Anderson and Ambassador Felson indicated the point about elections, getting people elected to various bodies. I would like to make a specific point about these bodies because in the inter-American context, there has been a long-standing effort to get more Caribbean persons on the Inter-American Commission on Human Rights. The membership is 7, and usually there is only one person. There came a time when 2 people got on, Justice Tracy Robinson and Rosemary Bell-Antoine got on, and I think we saw coming out of that the common law approach to inter-American human rights issues. And I think that's important because there are various bodies that are perceived by students to be far away from us. So the Inter-American Commission and Inter-American Court is a place where there are no Caribbean judges there. Margaret Macaulay was once there and she's now on the commission. But there is just this feeling of a distance between the Caribbean and the Inter-American system. Another thing that Caribbean states can do is become parties to the compulsory jurisdiction of the International Court of Justice. I made a list somewhere. Barbados, Haiti, Dominica, and Suriname are the only CARICOM countries which are party. But others could become party. There seems to be reluctance to embrace the jurisdiction of the International Court of Justice. And I think we will generate more interest in international law if we do become party to the compulsory jurisdiction of the court. I think the work by Justice Anderson on Eminent Jurists is an outstanding publication. And maybe we should think about eminent jurists next. The people who are in the next generation of lawyers coming through, we need to provide opportunities for them to write. Right now in the Caribbean, there are limited options if you want to write about Caribbean issues of international law. So we need to find avenues for that. In terms of the level of interest, I would say that I'm not pessimistic. When I look at some of the students who have gone through the system and have graduated, quite a few of them have gone on to master's work, especially at Cambridge or London, and have come back with a zeal for international law, which I think is important. And I think we need to continue encouraging that. And finally, when we talk about generating interest in international law, the CCJ, I think, has an important role to play. And the CCJ, by showing more and more interest in international law, is playing that role. I remember that there is a decision of the court in which it was an interim kind of decision. And the court actually said, well, when you're arguing an international law case, here are the things that we are expecting to see. We're expecting to see Article 38, paragraph 1 of the statute of the ICJ for the sources. So you don't argue a reasonableness point following Wednesbury and domestic law rules. You argue an international law point on reasonableness using other sources. And I think that kind of thing sets guidance to the legal community and is of considerable value.
Thank you so much, Professor Vasciannie, for those very, very useful interventions. If I looked like I was scribbling and taking notes, it's because all of our panelists have been even giving us at the International Law Association Caribbean branch ideas about what some of our future activities could look like, and some of the future interventions that we could perhaps prioritize. So thank you so much to all of our panelists for that. I am going to invite our esteemed panel to leave our attendees with any last thought, any single thought. I mean, you've graciously shared so many with us already, but if there's a lasting thought, a single thought in a minute that you wanted to leave with the participants, what would it be? Justice Anderson, I'm going to start with you. That's the order we've been using today. I'm not going to break it up now.
Be proud of your heritage. Remember that we have had tremendous persons who have contributed to international law, who have gone before us. You know, stand on the shoulders of those persons gladly and proudly, and go forward to make, you know, a further, even more impactful contribution to international law. Just to say as well that we have talked about developing contacts within our region, and that is fine, but of course, we have to look beyond the region as well. And the Latin America region, we do have some issues, of course, primarily when we are competing for the same positions. But the Latin America region represents an area where we can expand and identify new partners. We recently had a very important agreement, the Escazú Agreement on Environmental Law between Latin America and the Caribbean. Both regions collaborated together very, very nicely. The agreement has just entered into force. So that's, I think, an entry point into a greater collaboration. And then internally, there are further collaborations that we can foster. I have something to do with the CCG Academy for Law. And I know that under your able presidency, the Caribbean branch of the ILA will go from strength to strength, and we look forward to collaboration between the branch and, of course, the Academy. It was a pleasure being with you, a pleasure seeing I wouldn't say my old friend, but my friend of long standing, Professor Vasciannie. Pleasure meeting the ambassador, and of course my friend, Justice Kafour. I see, of course, as well Alana, as colorful as ever. I'm very glad to see her. And you, Madam President, it was a joy, of course, working with you. Thank you all.
Thank you so much, Justice Anderson, for those kind words and wise words as well. Ambassador Felson, what would you like to leave everyone with as your final thoughts?
One thing, I think we're best when we work together. I think we need to continue to support each other. We learn from each other and we grow together. And in that way, we will continue to be, you know, at the forefront of making good law for the international community broadly. Thank you.
Well said, Ambassador Felson. And finally, Professor Vasciannie, what would you like to leave everyone with as your final thoughts?
One, we should note that St. Vincent and the Grenadines holds the presidency of the Security Council of the United Nations, which is a major vehicle for the development of international law. Two, we should try from the Caribbean to get someone onto the International Law Commission at the next round of elections. Three, Jamaica should ratify the first optional protocol to the ICCPR. Four, Jamaica and any other Caribbean countries which have not done so should ratify the Rome Statute on the International Criminal Court. Five, we should encourage the publication of practice in the Caribbean. And six, the ILA branch, Caribbean branch, could publish the work of emerging international lawyers. And finally, I'm going to go and tell my sons that I had this morning with a judge, an ambassador, and various distinguished persons in the world of international law. Thank you very much for this invitation.
Thank you so much, Professor Vasciannie, for those final thoughts. And it's really just for me at this stage, on behalf, first and foremost, of my fellow members of the executive, Miss Alana Lancaster, or Treasurer, and Justice Anthony Gafor, or Honorary Secretary, and as well all other members of the ILA Caribbean branch, to first thank our esteemed panelists for such a vibrant and rigorous discussion. We are so pleased as well to have partnered with the Faculty of Law at UWI Cave Hill. We look forward to partnering not just with the university, but with other like-minded partners around the region. Thank you so much to everyone for participating in this wonderful dialogue, and do enjoy the rest of your day and the rest of your week. And we look forward to engaging you in further activities. Take good care, everyone.